SwayamPrabha. Digital India. Educated India.
Okay, welcome back all of you to the final lecture of this course, which is the name of the course is Law of Torts, Consumer Protection and Motor Vehicles, and this is the last lecture, the 20th lecture, where we are going to discuss about grant of compensation to motor accident victims. Now, in the previous lecture, you saw the structure of how liability has been developed and the insurance mechanism under the Motor Vehicles Act to ensure better safety of people who are using the road or road transport. Now, unfortunately, how much law tries to ensure safety and security, still accidents do happen. It's a reality, and in India the number of accidents have not very substantially reduced even after very many legislative and other policy provisions which have been incorporated in the recent past. So, therefore, it is equally important to find out that in case if there is an accident and a person have suffered a loss of or injury or has unfortunately died in the accident, then what is the mechanism of getting compensation and what is the computation model. In this lecture, we will cover these following 4 important topics. First, entitlement to compensation in road accident cases. Who is entitled to be compensated in road accident cases? Second, the principle of just compensation. Now, it is very difficult to compensate death by any mechanism. Life is so precious that when a life is lost, compensating it through monetary terms, it is almost impossible. However, the law has to take a recourse, because otherwise it will be a very unjust society. So, therefore, law has tried to provide some kind of a development of principles which are considered as just compensation. It is never equitable to a life of a person or what is worth, but a just compensation. And what is the policy of this just compensation as has been elucidated by judicial decisions in various courts in India as well as courts abroad. We will discuss this in this topic. Third is the computing mechanism for awarding compensation for case of death, and fourth is computing mechanism for awarding compensation in case of personal injury which has not resulted to death. So, we will start with who is entitled to compensation in road accident cases. Now, when a road accident happens, it can lead to 2 types of consequences. One, the person who is a victim succumbs to the injury and dies, or the person does not die, but he suffers severe injuries which leads him to a state of permanent disablement or even for a long time disablement, or maybe he or she is suffering from some serious traumatic scenario based on the nature of the accident, the veracity of the accident and all these factors. So, in order to therefore ensure that who gets the compensation, there are 3 categories as laid down by the various legal principles. One is in injury cases, it is the injured person who is the claimant. So, in case of person who has not died, but suffered serious injury which may be even leading to permanent disablement, in that case the compensation is given to the person or the compensation is claimed by the person who is injured through his legal representative of course, and he is called the claimant. In case of death, now of course the person has died, he is unfortunately no more alive to claim compensation. Now, as we saw in our previous 19th lecture that this old conventional law of torts maxim, actionia personis mater causa, persona mater causa, that means action in tort, personal action in tort dies with the or discharged with the death of the person, has been changed and completely removed from the legal parlance, and therefore now there is no problem of the legal representatives of the victim or the deceased person to claim compensation. So, in case of death cases, the legal heirs of the deceased are the claimants. So, the legal heirs of the deceased can be his direct legal heirs like his son, his wife, or even some cases who are not his dependents. So, in the first cases, legal heirs of first class will be the dependent person, direct dependents, so his son, his wife, etc. In case if the person has no direct dependents, there can be legal heirs who are entitled to compensation, such as brothers, or even in case where there is no dependent, his children who are adult, or his other persons. But there are some cases where this has led to some dispute. So, in the important case of Sarala Verma versus Delhi Transport Corporation in 2009, before Supreme Court, this question came that how do you determine, or whom do you determine to get the compensation in case of death, or where the victim is no more surviving. So, how do you determine that? And the court observed in this case and held, which I am quoting, the father is likely to have his own income and will not be considered as a dependent, and the mother alone will be considered as a dependent. So, in case where the deceased is survived by his father and mother. Now, in case of father, the court holds that because the father may have his own income, so he will not be considered as dependent, but mother who does not have an income will definitely be considered as a dependent. In absence of evidence to the contrary, brothers, sisters will not be considered as dependents, because they will either be independent and earning, or married, or dependent on the father. Thus, even if the deceased is survived by parents and siblings, only the mother would be considered to be the dependent. So, in case where there is no direct dependent like wife or son, or even if there is the direct dependent wife or son, when it comes to parents or siblings, then in that case there is a question that who is dependent of that person, and on the basis of who is dependent, when there is a case, then it will be considered as the mother of the person is the direct dependent, and the parents like the father, the siblings are not his dependents, because either the siblings will have their independent source of earning, or they may be married, or they may be dependent on the father itself. So, in that case they may not be entitled to seek compensation, but definitely the mother will be able to seek compensation, and the dependents will definitely be able to seek compensation. Now, moving to the second most important topic in this lecture, which is assessment of just compensation. Now, as I stated, life cannot be compensated, loss of life, sorry, not life, loss of life. There is no means by which a person's loss of life can be compensated in monetary terms. It is impossible to calculate. There are so many factors which is completely variable or completely impossible to ascertain in objective terms. For example, if a person who is working in a company where his current income is say 10 lakh rupees per annum, and he is of 30 years of age, but he has great educational qualification, and the company where he is working is one of the most eminent firms in that particular business or particular field, and he is considered as a very valuable asset. So, therefore, with the growth of the company and with time, his income is going to change. So, at the point when the accident happens, he may be earning 10 lakh, but it may happen that over a period of 5 years, it may be 50 lakhs. Now, he develops certain skills for which he becomes an invaluable asset in that market, and people are running behind him. So from 10 lakh he can jump a salary to 50 lakhs. Now how do you know? Secondly, the expectancy of life is something also you never can ascertain. So how long this person is going to live or survive? So therefore all these factors make it is impossible to actually calculate a just compensation in terms of loss of the life. So courts can only, and it has been assumed by courts, not only in cases of motor vehicles but in cases of any personal injury or death, that court can only grant compensation for the pecuniary and the monetary loss cost and some other expenses, but no court even attempt to grant compensation for the loss of life or limb. It is absolutely not possible. It is not possible for any court in the world to actually compute the actual loss of life or limb. What they can grant in the form of compensation is some pecuniary or monetary losses that are caused and some other expenses. And now that compensation, whether it is just or reasonable, has always been a question. But the attempt of the law has been that in such cases the compensatory model should be at least attempt to be a just model or just compensation. So what would be a just compensation in case of an accidental death or personal injury? Again, the courts have said, and I quote, statutory provisions clearly indicate that compensation must be just and it cannot be a bonanza. So what the statutes have generally mentioned is that when you are calculating compensation for such cases, it should be just compensation. It cannot be a prize or a bonanza at one hand, not a source of profit, but same should not be also pittance. So the just compensation should be that amount which should be computed and calculated by the court in such a manner that it cannot be a bonanza or a prize or a source of profit. At the same time, it should not be also treated as a pittance. So the courts and tribunals therefore have a duty in order to decide what is a just compensation by weighing various factors and quantify the amount of compensation which should be just. So therefore, whenever the court is tasked with this job of ascertaining what is the compensation that the court has to pay in that case, it is therefore the duty of the courts and tribunals to weigh the factors and various other factual aspects involved in that particular scenario and quantify an amount which would be just in that circumstances, right. And this has been generally the trend of law in all types of death and personal injury cases, whether it is amounting to torts or consumer cases or any other statutory torts, or in motor vehicles cases or industrial disasters or even cases of industrial deaths. This has been usually the attempt of the court. Now what is the objective behind determining this just compensation? The objective by which the court has been usually governed is it is given for the atonement of injury caused, and intention behind grant of compensation is to put back the injured party as far as possible in the same position as if the injury has not taken place by way of grant of pecuniary relief. So what the courts have tried to figure out as a matter of policy objective behind computing compensation or granting reasonable compensation is that as far as possible by way of this pecuniary benefit, the court or pecuniary amount, the court makes an attempt to put back the injured person to the same position as if the injury has not taken place by way of pecuniary relief. Now, although this is the desirable objective, but in reality it is not possible, and as I said at the very outset that it is not possible to by any pecuniary means to set a person back to the possible scenario what he could have acquired or achieved if this incident or if this accident had not happened. But The attempt of the court is that. That is the objective, that is the policy objective driving the court in determining the just compensation in this case. Now, there are various models, there are various principles over time that has been experimented, used globally to determine this, based on the policy objective that I just explained to you. However, these models with all its variance has never been considered as fully satisfactory. As I said, it is not possible. But there are some models which have been very critical. Scholars have said it is not possible. For example, a model which says that if his current income is say 5 lakh rupees, give him 2.5 lakh rupees and that is his compensation, 50% of his current income. Now, that does not figure at all any kind of his future possibilities. Similarly, actual terms compensation based on the losses, it is not possible. So, there have been various permutation combinations attempted globally in order to provide compensation. Now, one method that time tested manner has evolved, which has been also used by Indian courts, is the multiplier multiplicand method. Now, in India, in the case of Sarala Verma versus Delhi Transport Corporation 2009, this particular method was adopted and explained by the Supreme Court. Now, in that case, a young person who was a government employee survived a accident in a state transport corporation bus, Delhi Transport Corporation bus, at the time of commuting to his office, and he died on spot, and then came the question of paying compensation. So, initially the Motor Accident Claims Tribunal awarded him a compensation which was challenged by the State Transport Corporation as over and above in the Delhi High Court. The Delhi High Court came to another computation. So, finally the matter came to the Supreme Court, and the Supreme Court held that before you determine what is just compensation, you have to come up with what is the policy objective behind determining this just compensation. And what I have just read before you, the Supreme Court in this case held that the policy objective for determining compensation should be this, that it is given for atonement of an injury caused, and the intention behind the grant of compensation is to put back the injured party. This is important. To put back the injured party as far as possible in the same position as if the injury has not taken place by way of grant of pecuniary relief. So, that should be the driving objective or driving consideration for determining any method for which will be used for the purpose of computing the compensation in this particular scenario. However, the court said that it has to be also kept in mind that at the time of applying this policy, the most important aspect is that compensation has to be just, and just compensation, as earlier has been determined, should not be a means of profit or bonanza. It should not be seen as a profit or bonanza, neither it should be seen as a pittance. So, it should be a perfect weighing of the factors which lead to quantify the amount of compensation. Now, it is easy to write, it is easy to speak, but very difficult to actually compute. So, one method which has been used globally, as I said, was also attempted to be used in the by the Supreme Court in the Indian scenario. Now, this method is called the, as I said, multiplier multiplicand method. Now, in this method, there are two very important things. The court said that why this method can be used or considered to be just, because the number of factors that this method requires are comparatively less than many other methods, and these factors are also very reasonable in order to determine that to put back the person to the situation, at least in pecuniary terms, to where he could be if this incident of accident has not happened. So, what are the factors? The court said the factors which are essential for the purpose of using this computation method are age of the deceased person, what is his annual income, if there are any other source of income, what are those sources of income, and what is the income that is earning from those sources or the other ways, then how many members are there in his family, and with these factors you add some more other real expenses, and what the court says, then you can come up with a reasonably appropriate compensatory model, which will not only be able to balance between that profit bonanza versus PTNs, but also be able to put him back to the scenario which he was probably if this accident would not have happened, at least in pecuniary terms. Now, I am going to explain to you at the outset how this multiplier multiplicand method applies. After that, I am going to demonstrate by taking a hypothetical factual scenario the application of this method. And once we see, initially when I am discussing to you the method, it may appear to be quite complicated, but when you demonstrate it through the actual scenario, you can see if those informations and data are correctly available, then this method is not very complex and it can be easily achievable or attainable, and more or less it leads to some kind of a satisfactory or just computation as per the objectives of the compensatory mechanism in personal injury or death cases. So, the first thing is the step 1 in this method, which requires ascertainment of a multiplicand, right. So, the word is multiplicand. Okay. Now, how do you determine this multiplicand? For determining this multiplicand, what you necessarily require is the annual income of the deceased person. Now, one thing I want to tell you, this computation that I am doing here is only relating to death cases. This method is not utilized for personal injury cases. What is the method for personal injury cases? I will come little later, where death has not happened. But this method is applicable only for death cases. So, where the deceased person, what was his annual income at the time of his death? Now, there are various ways in which annual income can be determined. Now, for any person who is employed in a service, the best method of determining his annual income is to ask for the last 3 years return of the income tax. Now, income tax return is the first and the foremost way of determining annual income of a person. But if the person does not have a service employment or where he is not filing that, then it becomes a little difficult. Now, for agricultural income person, it becomes a little difficult. For persons who are informal service, it is difficult. But those who are in service, it becomes simply ask for the income tax return filed by that person for the previous 3 years. In case where that is not possible, then ask his legal heir to file in an affidavit what according to them was the possible annual income of that person. Okay. Now, once you have determined the annual income of the person, then the next important thing is to determine what is the personal living expense of that person. So, the first thing that you have to determine is the annual income of that person. Now, after you have determined the annual income of the person, the next thing that you have to determine is what is the personal expenditure or what is the expense from this income that he has incurred on himself. Now, for that usually 2 methods are utilized. The first method is called the unit method. Now, in this unit method, what usually happen is that the number of survivors or dependents of that person who are entitled to compensation, it is determined. So, if he is the sole bread earner in the family, then how many dependents are there? if he is not the sole bread earner of the family, then on his earning how many people are dependent. Now based on that number, each person has a unit. So for adults it is considered as 2 units, for children 1 unit. So if say there is a family consisting of 3 persons, 2 adults and 1 child, the number of units will be 7 units. 2 adults, 2 into 2, 4, 5 units, not 7 units, 5 units. So 2 into 2, 4, and 1 child is 1 unit, 5. So the total 5 units. Now based on this 5 units, now the total annual income that you have determined, divide it by 5 units. Now you will get 1 unit value. Now that 1 unit value, then what you do is that you multiply with 2 units, because 1 adult is 2 units. The amount you get, which is 2 units, you will then deduct that from the annual income, because those 2 units that you now get based on the unit calculation is called the personal living expense of the deceased. The second method is that you, from the total annual income, deduct 1/3. So divide the from the total annual income 1/3, and what comes out is the 1/3 is the personal income, personal expenditure or living cost of the deceased. Now sometimes this 1/3 deduction is usually considered to be little harsh, because people who have less income, now of course they do not spend upon themselves 1/3. If you have 1 lakh rupees annual income, you are not going to spend 1/3 of that income on you, and if you have 3 or 4 members in your family. So usually this 1/3 method is generally considered to be little harsh for that reason, because it does not give the actuality. So the unit method is preferred. So unit method is again I will repeat, and when I demonstrate it will be easier for you to understand, but I will just repeat. The unit method goes like this, that every adult and children members of the family of the deceased are taken together, and each of them are given a value. So adult 2 units, children 1 units. So if there is a family consisting of 2 adult and 1 child, so in total will be 5 units. Now the total annual income of the deceased will be divided by 5 units. Whatever the value comes, it is per unit value. Now this per unit value will be multiplied by the 2 by 2, because you are going to determine the value of the living expenditure of the adult person, because adult is 2 units. So therefore you have to multiply with 2, and whatever comes out is your personal living expense. Now after you have determined the annual income and you have determined the personal living expense using either of the unit method or the 1/3 deduction method, whichever, then you subtract the personal income of the individual of the deceased from the annual income, and whatever is the remaining sum is your multiplicand, because that is the family income. It is presumed that that much amount of money he would have contributed towards the family for its purpose of day-to-day expenditure, its future assets, etc. Now once you determine the family income, it becomes your multiplicand. Now comes your multiplier. The multiplier has to be ascertained on basis of a year of the decease. So that is why I said, what are the 3 important aspects in this method? 1, you need to know the age of the person, you need to know the annual income of the person, and you need to know how many people are there in his family who are his direct dependents. Now once you know these 3 things, then this method can be worked out, right. So now after you have determined the multiplicand, now comes the multiplier, ascertaining the multiplier, which is the second step. Now here a chart has been given by the court, and this is usually used globally. This chart was ascertained by Trilok Chand's case in the Supreme Court, and in this case the chart is based on year. So age of the deceased, younger he is, the more is the number of the multiplier. The more the multi of the number is higher, because he has a larger life expectancy, he has a larger potential of income increase, etc. Older he grows, the multiplier reduces. So, if you look at the chart presented on your screen, you will see 15 to 20 years. Now, below 15 years is considered as a minor, and because of our child Labour Act, nobody can be employed statutorily. So, therefore, below 15 there is no question of determining any annual income. From 15 to 20 the income range starts. So, 15 to 20 highest 18, followed by 20 to 25 years again 18. Then it gets reduced 26 to 30 17, 30 to 35 16, going above 65 as 5. So, as I said that the multiplier will be more if the age of the deceased is younger, multiplier will be less if the age of the deceased is older. So, once you know what is the age of the deceased, you can determine from this chart what will be the multiplier, and you have already determined the multiplicand by ascertaining the annual income and from there deducting the personal living expenditure of the deceased. Now, once you have determined both these two things, now comes the actual calculation, which is a step 3. And in the actual calculation, what you do is that the annual contribution of the family, the multiplicand, is once determined with subtraction from the personal expenditure, is multiplied with the multiplier. So, the multiplier that you have determined based on his age and the annual income, family income, you determine on the step 1. Now, step 1 and step 2 you multiply, and what you get is what is called loss of dependency to the family. So, the first unit in this method is of compensation is called loss of dependency to the family. So, how much is the loss of dependency to the family for that person's death, and you determine the quantified value by using this multiplier multiplicand. Now, in addition to this, what you add some more amounts to this is that you give him a rupees 10,000 as loss of estate. Second, if the person is survived by a wife, you give ranging between 10,000 to 20,000, a determined sum depending on the age of the wife, his abilities, his dependency level, an amount between 10 to 20,000, which is called the loss of consortium, right. If the wife is younger, then there was a possibility of family, growth of family, so the consortium is more. If the wife is older, then of course the consortium amount decreases, right. So, the third head is loss of consortium. You do not pay in case of death any amount for pain, suffering, hardship. You also do not pay for mental agony. What you pay, the last is funeral cost, cost of transportation of the body, cost of medical treatment of the deceased, and these are calculated on the basis of actual expenditures. So, whatever the actual expenditures incurred in this head, they are all calculated together, and therefore, on this 4 head you grant the compensation. First head, loss of dependency of the family to the family. Second head, loss of estate. Third head, loss of consortium, and last head, actual cost based funeral, transportation and medical expenses. All these heads added together is the compensation. Now, you can see therefore, my friends, that this model at least attempts to bring all the important losses, and as I said, the objective is to try to give him back some pecuniary mechanism to put him back into the scenario where he was, right. And by the multiplier based on age, what you do is that you factor in also what could have been the possible increase of the income. So, you do not leave it only what will be his income on that day, but all the possible to some extent abstractly you try to incorporate. Now, as I said that I will demonstrate before you this particular calculation for your easier and simpler understanding. So, let us take a hypothetical case where the person deceased is of 20-year age of the deceased is 28 years. So, the deceased age is 28 years. Now, the deceased is lived by a widow who is 21 years of age and a minor child of 6 years of age. The deceased had two primary sources of income. One was he was a mechanic in a famous company Maruti's garage. So, his annual income from that was 6 lakh, and by affidavit the wife has placed that he was involved in vending of milk, and in that process daily he used to earn approximately 600 rupees. So, if we calculate therefore from milk vending source, as far as the 6 lakh rupees from the Maruti, there is a service contract which provides what is his income. In this case, or income IT return also may be, but let us say Maruti company's service contract provides that he will get a salary of 6 lakhs. Plus, in this milk vending business, he used to, as per affidavit of the wife, 600 rupees per day. So, 600 into 30 into 30 into 12 comes to 2,16,000 lakh. So, therefore, the total annual income of the deceased is 8,16,000. Now, what is the composition of the dependents of the deceased family, including the deceased? Husband, wife, a minor child. Now, as per our unit method, we are applying, say first we will apply both methods. Now, as per our unit method, as per so determining the personal income, personal income and personal expenditure. So, we use unit method. Total members are 2 adult plus 1 child, 3 adult plus 1 child, I made a mistake, a wife and a dependent mother, and a minor child, mother is of 70 years of age. So, wife, mother and minor child. So, total 3 adult and 1 child is equal to 7. 3 into 2, 6, 1 into 2, 2, 6 plus 1, 7. So, 7 now divided by, so now this 7, so this 8,60,000 to be divided by 7. Now, by dividing 8,16,000 by 7, the calculation that comes is somewhere close to 1,16,572. Now, this multiplied by 2 unit, whatever is the value, that when subtracted from 8.16 lakh, what we get is 544,600, and this is the family income. So, this is the income that I was spending on my family, or this person was spending on the family. Now, the age of this person, so we have used this 3 indicators. Now the only indicator is age. Now age of this person is 28. So based on our the chart that we have seen, 28 means the, okay, I will go back to just help you to understand. So if his age is 28, it comes between this 26 to 30 years, so 17. So 17 is the multiplier. So what we need to do is that we need to multiply this. So multiplier versus by, this is the multiplicand, and the multiplier is 17. So the multiplier, so the, now coming to the step 3, which is actual calculation. So to determine the first unit, which is loss of dependency of the family, is multiplier into multiplicand, sorry, multiplicand into multiplier, that means 17 into this 544600, which comes to the figure of 11 lakh 720,276. Now with this we add loss of estate, which is 10,000, loss of consortium, which is, say, in this case, because the wife is 21, there is all possibility of loss of consortium zyada more. So 20,000, and funeral and other miscellaneous expenses, medical cost and other miscellaneous expenses, altogether 1 lakh based on the real calculation. Okay. So this whatever is a sum, this is what is a compensation to be granted. So you can see with these 3 factors, the court can come up with an appropriate model, effective model, but it is easier said than done, because there are many factors which are not so easily available. This was the hypothetical case on the basis of which we have determined this. All the factual parameters are provided here. So as I said, it is easier than done. Sorry, not this. This is not the factual parameter. Sorry, there are other factual. The factual parameters were not provided by you to you. Factual parameters are what I have written here. So this is, as I said, easier than done, because there are many things which are not available readily. Many calculations are there, then appeals happen, they say this is not right, this is not right. So that is, but more or less you can see that this is one method which can be of substantial just towards finding a just compensation. Now the problem arises is when in case of persons who do not have a appropriate certificate of annual income. For example, a housewife. Now a housewife does not have an annual income. In that case, how do you determine the annual income of the housewife? Now one is that housewife is considered to be a somebody which you fix a particular any amount, but that is not fair. In Arun Kumar Agarwal case, Supreme Court has observed that it is highly unfair, unjust, inappropriate to compute the compensation payable to dependents of a deceased wife mother who does not have regular income by comparing her services with a housekeeper or a servant or an employee. So sometimes that has also been done. So that is not fair. So what the court said, that one is in 1994 the Union Legislature tried to fix a sort of a model for non-earning person, that for any non-earning person rupees 15,000 is per annum income, and it is 1994, highly unrealistic, but still it does, it is that amount. Second, in case of spouses where there is a living spouse who has annual income, then 1/3 of the spouse's income is considered, as we have determined by the earlier calculation. 1/3 of the spouse's income is determined as the income of the wife, and accordingly it is computed in the multiplier multiplicand method based on that loss of dependency, etc., etc. Now, in absence of either of that, now this two system has been speculated or stated in not in the way for wife, but says that in case of person who does not have an income. In that case, in schedule 2 of the Motor Vehicles Act in clause 6. So, clause 6 schedule 2 of Motor Vehicle Act is a guidance toward this. So, one of the ways to determine for persons who do not have a real income, their annual income, is using the determination process that is specified in the schedule 6 in the schedule 2 clause 6 of the Motor Vehicles Act. Another problem is what happens to death in case of child, because in the schedule that is prescribed in the multiplier, you saw that incomes are computed, age is computed only after 15 years, and below 15 years, as I said, that there is a Child Labour Act which says that you cannot employ usually. So, and it is not encouraged. So, therefore, it is not presumed that a person below 15 years will have an income. So, therefore, how do you determine that? Now, you can determine using that schedule 6 criteria, or you can use either one give a common amount, because there is actually no loss of dependency in case of children, but what you can do is that you can award a fixed amount and then pecuniary losses can be determined on the basis of that, and compensation can be granted. But what courts have said in R.K. Malik case is that you need to keep in mind the future prospect of the child, and it is incumbent upon the court to consider the said aspect while awarding compensation. So, that is absolutely essential and that is absolutely necessary. Now, coming to the next category, which is compensation for injury cases where death has not happened. Now, there compensation is calculated in these two heads. First, pecuniary damages, damages in the form of pecuniary losses, medical treatment, attendance, transportation, special diet, all based on actual cost that has been provided by the claimant. Second, actual loss of earning of profit up to the date of trial. So, he was unable to attend office, no pay was given, whatever loss of income that he has happened due to this accident, all that in a real term he has to provide either through a certificate by chartered accountant or through any other source certified that this has been my loss of income. And last is future loss of earning. So, if he was in a kind of job, now because of the accident he is not going to able to perform that job. Now, that will lead to a future loss of earning. So, that future loss of earning has to be determined. Now, there usually the courts have used the multiplier multiplicand, the multiplier method, not the multiplicand, they have used the multiplier by using the what is the current job scenario and his skills, his educational qualification, his prospect for enhancing his career, and the basis of that a sum has been compounded, and then based on his age a multiplier has been determined, and which has been now used, which has been then used for the purpose of determining the future loss of earning. The second head, where in injury cases pecuniary damages have been provided, is damages for mental and physical shock. So, as I said, in case of death, there is no question of payment of any sum for the purpose of mental agony, because the person has died. So, mental agony is not for the representatives. Legal heirs can get for loss of dependency, can get for loss of estate, can get for loss of consortium or the real expenditure, but for not mental agony. Of course, they also had gone through mental agony, but law does not provide or account for compensating for that mental agony. But when it comes to the injured person, definitely he is undergoing mental agony and he will continue to undergo mental agony. So therefore his mental agony has to be, and physical shock has to be accounted for. Then pain and suffering, whatever pain and suffering he is incurring has to be taken into consideration, and what likely to be suffered in future. So there are cases where a person who was walking on the road met an accident and he lost his limb and he was not able to walk anymore, and that condition forced him to psychological disorder, and that psychological disorder led to his his disbalance of mind, leading to some psychological state which made him to commit suicide. Now whether this subsequent psychological disorder leading to suicide all be accounted for calculation of this shock pain amount, yes. The courts have said that unless there is a particular act which we have discussed, novus intervenus, the break of circumstances of chain of causation. In damage chapter, you remember we have discussed novus intervenus, novus actus intervenus. Unless novus actus intervenus has happened which broken the chain, then all these has to be accounted by the court in the head of physical shock, pain, suffering, etc., etc. And the next head is damage to compensate for loss of amenities of life, which may include variety of matters. For account of injury, the claimant may not be able to walk, run or sit. So he was an athlete. Now because of his injury, he lost his limb. Now loss of limb means that he will not be able to perform those things he was doing. So his athletic career comes to a finish. Of course, that can be also figured in future loss of earning, but if he was not a professional athlete, he was an amateur, he used to take part in amateur marathons, okay, then in that case there may not be a loss of earning, but definitely it is a loss of amenity of life, because for him participating in the marathon was such an important aspect that once he is discarded from that, he loses important part of his life or important part of his natural abilities. Similarly, if he is a person who is interested in painting or drama and he loses his eyesight because of the accident, now that is a huge loss of amenities for him. So therefore the court has to take account of this loss also. So in case of therefore personal injury cases, the nature of computing damages is different from the death cases. As I said, in death cases, the heads are loss of dependency, loss of estate, loss of consortium and funeral cost, medical cost and other miscellaneous cost on basis of real. This is where are the computation factor for death. But in personal injury you can see the heads are two, pecuniary and non-pecuniary. In pecuniary you see medical treatment, attendance, transportation, special diet, real. Actual loss of earning of profit again based on real accounts. Future loss of earning where the multiplier factor will come plus determining what could be the possible future loss of earning. And there are some non-pecuniary damages which are usually not provided in case of death. It is only peculiar to personal injury, which is damages for mental, physical shock, pain, suffering or damages or compensation for loss of amenity of life, right. So this therefore shows that we have developed a model of computing compensation to ensure that at least pecuniarily we do not make that person or his family in a disadvantaged position for the unfortunate incident. Said so, it is, as I have mentioned earlier several times, that life or loss of limb cannot be compensated. That is something that the courts across the globe have accepted, that no compensation can be just or reasonable for that. So with this I end my lectures of this particular topic as well as of this course. it was really enjoying for me to engage in this lecture. I am sure some productive learning will be happening through these lectures, and I will be happy if my deliverance, my thinking in this subject being associated with teaching for last almost 15 years and my passionate or my advocacy for promoting a better governance model for law of tort will be of some use for all of you. So, with these words I want to thank, and I want to congratulate, and I want to again express my gratitude to the SwayamPrabha system for providing me this opportunity to share my thoughts in this wonderful platform. All the very best. Thank you.